My name is Luis Onatin, and I am the current chair of the Miami International Arbitration Society. As part of one of my many initiatives is I'm going to start interviewing certain people within the arbitration community to talk about arbitration and hopefully talking about arbitration in Miami. I am very fortunate that for my first guest, I have Alexis Moore. Alexis needs no introduction. He's the president of the court for the past 4 years. Alexis, thank you so much for being my first interviewee. Alexis, when you became president of the court, that was about 4 years ago. Arbitration has been in the news a lot more than any of us would have ever expected, mostly not for good reasons. When you took the helm 4 years ago, what were your thoughts? What did you want to accomplish by being president of the ICC court?
I became president of the court in July of 2015. I had been before vice president under the presidency of John Beachy for 6 years. So I came in with pretty good knowledge of the institution and of how it could at the same time continue to be successful as it has been in the past, and at the same time improve its services and also address the new challenges that we are now facing. Of course, the main question that any institution has to tackle is the question of the time and cost efficiency of its services, which is, and rightly so, the main concern of users. And we have done that at the ICC in many ways, recently by introducing expedited rules for claims of limited value, and we are now thinking of improving that system by increasing the threshold for the opt-out application of the expedited rules. We have, as you know, introduced a time limit for the submission of draft awards by arbitrators to the court. As you know, any ICC award has to be scrutinized by the court before it can go to the parties. And we have, since 2016, established a time limit for submission of draft awards by arbitrators, 3 months for 3 members tribunals, 2 months for sole arbitrators.
How successful has that been?
It has been very successful, and as you know, it goes with fees reductions in case of a delay that is not justified by the circumstances. And if we look at the statistic, we see that we have about 50% of awards that come to the court with some delay. Of course, it can be a 1-day delay and can be a 1-year delay. Fortunately, we don't see many 1-year delays, but it can be any delay. And in 50% of these cases, we apply sanctions. That means that the court finds that the delay is justified in about half of the instances in which there is some delay. Some delays, as I said, are de minimis, others are not, but can be justified by the complexity of the case and by other circumstances. But in 50% of the instances in which there is a delay, there is some level of fees reduction. It has been very effective. We have seen a very significant reduction of the time that it takes to receive draft awards. We no longer see, as we had seen in the past, large delays of 7, 8 months, 9 months. The time limit counts after the last substantive submission, which can be the evidentiary hearing or a post-hearing brief. We have seen a very significant reduction of the time that it takes for tribunals to submit their draft award. So it's a significant improvement of the efficiency of the system.
And it's not just that, because the court itself, for people, you and I know that we're filming this during the ICC annual ICC conference in Miami. Now Spanish language awards are not translated.
No longer.
And so the efficiency of the court itself has changed.
Exactly. And we apply also reduction in our own administrative fees in case of delay in the scrutiny. We have done that in some instances. We now have a situation in which awards are scrutinized in 2 weeks, 3 weeks, on average. So that's very good. We have introduced also measures to increase the efficiency of the arbitral procedure itself by, we in particular, introducing guidance in our practice note on summary dispositions, which are, I think, quite useful. So there are a number of measures that have been introduced, which I think are making ICC arbitration more efficient and completely in line with any other system of arbitration. Bear in mind that our cases are more complex, are larger. We have more multi-contract, complex, multi-party, high-value cases, which necessarily take longer. But I think, all in all, we have been implementing a number of measures which have been very productive in terms of reducing the time and cost of ICC arbitrations.
Now, the legitimacy of arbitration is called into question regularly in the news, and the question of transparency and things of that nature. How have you dealt with that during your time?
It's a very important question. Many practitioners think that transparency is only a question for treaty-based arbitration, and of course we all know about the UNCITRAL rules on transparency and the Mauritius Convention. But I think it's a question for commercial arbitration as much as for investment arbitration, in the sense that we at the ICC, we first have a number of investor-state treaty-based disputes, but we also have a very large part of our caseload involving states and state entities. It's about 20% of our caseload. We now have a caseload of about 1,600 pending cases. 20% of these cases roughly are cases where the public interest is directly at stake. So transparency is a very important question. We have dealt with, and transparency of course is as much transparency in the institutional decision making and institutional practice and institutional composition of its leadership as for the arbitration itself. And we have taken a number of measures in this regard, which I regard as important. The first is we have modified the rules, the ICC rules in 2017, to allow the court to provide reasons for its decisions upon the request of any party. So it's no longer subject to an agreement between the parties as it was before.
You're talking about, say, a challenge to an arbitration?
Well, not only challenges, but also, and that's where ICC has gone further than other institutions, it is decisions made on prima facie jurisdictional decisions that the court makes when the court decides in presence of a jurisdictional objection that the case may or may not proceed with respect to one or more of the claims or one or more of the parties. So these decisions are subject to the provision of reasons as well, and consolidation as well. But of course, in most instances, it is decisions on challenges.
But you've gone further than that. You know, the concept of publishing lists of arbitrators. Are you also publishing the name of counsel in the?
Yes. So so that the second thing that we've done is to, as from 2016, to publish the composition of all ICC tribunals. So anyone can now see by going on the court's website who sits with whom in any ICC case. We are now expanding since this year this information with the names of counsel and also an indication of the sector of industry which is involved. Of course, the confidentiality is preserved by the fact that you don't see the case number on this list, so you cannot find what is the case that is exactly related to the names that are on the website, but you see for each case the three members of the tribunal and the way they've been appointed, the name of counsel, and the sector of industry that is at stake.
And I take it what we're trying to do here is demystify a little bit the arbitration. Everyone says there's just 15 people, it's a very closed society.
Arbitration, and I'm talking of international commercial arbitration, is moving away slowly, but I think that process will not stop, moving away from its culture of secrecy, which was absolutely the dominant view perhaps 10 or 15 years ago. Everyone would say, yes, arbitration, of course, is by nature is confidential. I think that the culture is now shifting, to more transparency and more openness, and that is very good. That is very good, and what we are doing, of course, is part of that evolution. Another thing that we've done is to adopt this year quite a bold policy to systematically publish ICC awards with the name of the parties, with the name of council, unless, of course, there is a confidentiality agreement somewhere in the contract or in the terms of reference, or unless one of the parties objects. So there is a process whereby we give notice to the parties at different stages. First, at the time of the registration of the case, and then at the time of scrutiny, and then before publication. So the parties are made aware of the policy, and if no party objects, then the award gets published. Of course, we have quite a significant number of parties who do not wish their award to be published, but still I think we'll end up with a very significant portion. I mean, something between 30 and 40% of our awards that will be published, and the policy provides that the publication takes place 2 years after the award is notified. So there are lots of belts and suspenders there. But I think that this will produce also a change in culture, and it will have an important effect on the normativity of awards, because you will have a very large amount of data available to the public. Of course, the question will be to have a proper search tool to allow that information to be useful. But if it's done properly, it will have an important impact on the way in which awards contribute to the formation of the rule of law.
Well, that raises a whole host of interesting points, because as you first pointed out, the culture, you mentioned a culture of secrecy. I'm not sure parties would have necessarily described it that way. They would view it as, one of the benefits they would see in arbitration is that it was a confidential process. And so if they had a dispute with a long-time provider or whatnot, that dispute does not get aggravated by being in the public. So that's going to be a change in the way parties look at arbitration, no?
Yes, I mean, we're of course deeply conscious of the importance of business confidentiality, and we're completely conscious of that, and we're completely respectful of the parties' legitimate expectation to confidentiality. Now, we have to be sincere. I mean, that these expectations are watered down in a number of ways, and not by us. You now have, first of all, the press publishing awards by itself. You have reporting obligations, which are more and more pervasive. And I think in the world of business, not only arbitration, secrecy and confidentiality is less and less relevant. You have many ways in which in the society at large transparency becomes a more relevant principle, including in business relationship, and that of course applies to arbitration as well. Of course, again, we are establishing lots of belts and suspenders. There are confidentiality agreements in contracts in terms of reference. There are areas of business in which we do not publish anyway, because we know that there are considerations. But in those awards, you would have a confidentiality agreement somewhere anyway. Like gas pricing dispute will not be published.
Following up on the issue of normativity, because remember there was the English judge that was complaining that there's not enough jurisprudence.
No.
You have ICSID awards are published, and suddenly that's kind of created a common law jurisprudence of you're trying to follow precedent.
No.
Is that going to happen with ICC? Certainly, ICC decisions, certainly as they relate to ICC procedure. How do the publication of these awards is going to have many different ramifications, including what I'm talking about.
Yes, I think you need to distinguish procedural matters from substance. As far as procedure is concerned, I think it will provide very useful guidance to arbitrators. As far as substance is concerned, you will need to see what the sector of industry that is at stake is. There are, for example, there are industries where almost all disputes are arbitrated. Construction, for example. If you don't have access to awards, you don't know what the law is. And I think in that kind of industry, yes, making available hundreds of awards with the proper analytical tools will change the culture in a way, and that it will, in the sense that it will make references to past commercial awards more reliable than it is now. Now what you have is a very small pool of decisions. You're not able to see trends. You see, of course, in submissions, you see parties picking up what they can find in publication, but it's not very relevant because you don't see the trends. Now, what you will have is a trend. You will have the massive information allowing scholars and practitioners to see what the dominant trends are on certain questions.
Well, more than that, because again, going to the idea of expanding this pool. Until now, if you're not an experienced arbitration practitioner, the ability to go ahead and find, precedent on certain procedural issues, exactly, it was just much more difficult. By going ahead and publishing this, you're going to be opening up the process to
exactly. It will also create a more level playing field. It will, of course, open information to more players, which is good as well.
Which leads me to my next question. Diversity, gender, geographic. You've made, I think you're rightfully proud of the advances that you've made on that. Can you?
Well, I think the situation we had and we still have to a certain extent is a scandal. We still have less than 20% of our arbitrators, but I think that's true for the ICC, that's true for any other institution being women. We have taken measures which are unprecedented in the ICC history. We now have a court with complete gender parity, which, as I said, I'm very proud of, but we need to do more. We don't have enough women in our tribunals. We still have a situation in which, from the statistics I saw last year, about 70% of the total population of arbitrators still originates from North America and Western Europe, which is not reflective of the reality of today. We need more arbitrators from Africa, from Asia, certainly, Latin America as well. And there is the question of a generational change. There is a new generation coming to the forefront, and I think it is the role of the institution to help them. Becoming, getting appointments and coming to the forefront. So that's diversity. It's a very important topic.
And then let's go ahead and start talking, finishing up, because I want to keep these things relatively short. How about the question of arbitrator disclosures? Again, going back to the legitimacy of arbitration, the question of those disclosures are quite important.
I think it's perhaps the most important question for arbitration today. It's a question of disclosures. When we talk about arbitrators' ethics, and it's a subject on which now Ancestral will start working, and many other bodies, you're essentially talking about disclosures. And to us, it is a fundamental principle that the parties are entitled to know whether there are circumstances such as to affect the independence and impartiality of arbitrators. We have adopted, for the first time in ICC history, but in 2016, we have adopted guidance of our own. Before, there was reliance on the IBA guidelines on conflict of interest, but that was written nowhere. So, no one would exactly know to what point the ICC would rely on the IBA guidelines and where did that stop. There was a lack of transparency. Now we have detailed guidance in our practice note on disclosures, and it is to a certain extent more demanding than what the IBA guidelines provide. For example, we don't have in our practice note the three more than 2 appointments over 3 years threshold that is in the IBA guidelines. For us, it's a very important point of policy that disclosures needs to be transparent and forthcoming. And although the note makes it clear that a lack of disclosure does not result automatically in a disqualification. It is something to which we give great relevance and which we assess with rigor at the time of deciding on objection to confirmation or on a challenge.
Okay, and then one final question. How great of a place is it to arbitrate in Miami?
Miami is a great place. Miami is a great, no. Miami really, I mean, Miami is already an important international arbitration hub. It is no longer a place that needs to affirm itself on the international scene. I think Miami is now, in particular as far as arbitration involving Latin American parties, one of the main arbitration hubs in the world, and rightly so. It has a solid arbitration community, it has solid court support, I think it has great infrastructures, and so the fact that the arbitration community here in Miami is continuing its effort to promote the city as an international venue is great.
Well, I think with that there can be no better closing than that. Thank you very much,
Thank
Alexis.
you.